Samantha, one night in January 2017, Samantha went out with a few friends and coworkers. She woke up the next morning in a coworker's home, confused, scared, covered in blood. She'd been raped. After she was raped, Samantha was, in her words, a zombie. She couldn't change clothes, she couldn't shower, she couldn't drink or think. She wanted this event to be erased from her memory. Samantha's attacker also began stalking her, and she was struggling with depression and PTSD. In March, Samantha took a pregnancy test, and then another, then another. They kept coming back with the same result: pregnant. After the horrible violence she faced, she simply couldn't process that she was now pregnant. When Samantha shared her story with me, she said, "I knew if I couldn't end this pregnancy, it would end me." So she decided to get an abortion. Now, as you know, Judge, the landmark Roe v. Wade decision gave her that option. It gave women the right to decide for themselves whether and when to have a child. Roe didn't compel Samantha to get an abortion. It didn't tell her what she had to do, but it gave her that choice. The question that I would like to ask you concerns your legal position. Does the Constitution protect Samantha's right to have an abortion?
Roe versus Wade clearly held that the Constitution protected a woman's right to terminate a pregnancy. Casey upheld that central holding and spelled out in greater detail the tests that the court uses to consider the legality of abortion regulations.
A very tense moment during the confirmation hearings for Justice Amy Coney Barrett. That was Senator Blumenthal from Connecticut. And right now, the Supreme Court is considering which cases they are going to consider. And there's one out of Mississippi which does involve an issue that could impact Roe v. Wade. Michael Ayala has the story for us.
We will continue the fight to make Mississippi the safest place in America for an unborn child.
Mississippi lawmakers expected a court battle when they started passing some of the country's toughest abortion restrictions.
And I have absolutely no problem supporting strongly whatever it costs to defend this lawsuit, because I care about unborn children.
The fight over one of those measures, a 15-week abortion ban, may reach the nation's highest court, setting up a potential challenge to Roe v. Wade, the landmark 1973 Supreme Court ruling that legalized abortion before viability.
Mississippi's request that the court take this case really asks the court whether a state can prohibit abortion before viability, whether the state can go against this fundamental principle of Roe v. Wade.
Should the justices decide to hear the case, it could serve as a litmus test for the court and its newest member, Amy Coney Barrett. With Barrett's confirmation, the court has a 6-3 conservative majority that could tip the scale toward more abortion restrictions.
Two cases that she considered as a federal appellate court judge, she indicated opposition to abortion rights.
In her confirmation hearing, members of the Senate Judiciary Committee pressed Barrett on whether she would follow Supreme Court precedent and how her personal opposition to abortion might influence her on the bench.
I feel like I should emphasize here, as I emphasized to others asking me the question, that I do see as distinct my personal, moral, religious views and my task of applying the law as a judge.
The dispute over Mississippi's abortion ban could offer preliminary signs of Barrett's leanings. Former Governor Phil Bryant signed the House Bill 1510, the Gestational Age Act, in 2018. The act bans abortions after 15 weeks, except in cases of medical emergency or severe fetal abnormality. Hillary Schnellner is an attorney at the Center for Reproductive Rights. The center represents the Jackson Women's Health Organization, Mississippi's last remaining abortion clinic, which sued to block the ban.
Both the district court and the Fifth Circuit Court of Appeals struck the 15-week ban down as unconstitutional because it directly violates the core principle of Roe v. Wade, that states cannot ban abortion before viability.
The state appealed the decision to the Supreme Court, claiming it has a legitimate interest in regulating abortion before viability. The state also questioned the clinic's standing to challenge a law. The case is one of many involving abortion restrictions that could have massive implications short of overturning Roe.
In many parts of the country, abortion is very difficult to access because law after law after law has been passed to restrict abortion. The Center for Reproductive Rights and others have blocked many of those laws, but should they take effect, abortion access could be decimated even as Roe remains the law on paper.
All right, let's bring back in Court TV anchor Michael Ayala. Michael, as you look at this case, what makes this one so important?
Well, as I said in the piece, Vinny, this is taking, it has its crosshairs right on Roe v. Wade. Other cases have tried this, but with a different configuration of the court. So they're watching closely to see if this one gets to the court. And the idea is that Roe v. Wade says that viability begins at about 23 to 24 weeks. And again, the conservatives say that that's a bit of an arbitrary number, but that's an issue for a different time. And Mississippi wants to state 15 weeks as the time where it's the maximum amount of time. So this, if in fact it is taken by the court, right, it's going to go right at the heart of Roe v. Wade. But there is an important thing to consider here about Amy Coney Barrett's presence on the court before that point. It takes 4 justices, right, to hear a case. And previously, some cases that have come before the court, Alito and Thomas and other conservatives may have not wanted to hear them because they didn't feel they had the proper majority to change them if they felt they required changing. Now with Amy Coney Barrett, these are the kind of cases that may make their way through to the court.
So if this case goes through, does it raise the possibility of overturning Roe v. Wade?
It absolutely raises the possibility. This is not the one that's going to overturn it. It could shorten the amount of time, which would then, it would just be then a matter of time before Roe v. Wade finds itself under direct attack. Now, at that point, the court's going to find themselves in a position where they have to ask, how important is Roe v. Wade as precedent? Again, precedent is they give great deference to prior decisions of the court. It's the law of the land. It's been the law of the land since 1973, decided by the Supreme Court. They need good reasons to overturn precedent. Some judges are more apt to do it than others. How does Amy Coney Barrett look at that situation? We have her own words to look at the confirmation hearings. Let's take a listen.
Is Roe a super precedent?
How would you define super precedent?
I might have thought someday I'd be sitting in that chair. I'm not. I'm up here, so I'm asking you.
Okay, well, people use super precedent differently.
Okay.
The way that it's used in the scholarship and the way that I was using it in the article that you're reading from was to define cases that are so well settled that no political actors and no people seriously push for their overruling. And I'm answering a lot of questions about Roe, which I think indicates that Roe doesn't fall in that category. And scholars across the spectrum say that doesn't mean that Roe should be overruled, but descriptively it does mean that it's not a case that everyone has accepted and doesn't call for its overruling.
So I think it's pretty clear there, Vinny, where she stands if confronted with precedent, if she feels it was decided wrongly, if she feels there's enough of a groundswell that it should be changed. I don't think she's going to have a lot of problem to change it. Now, if it's changed, Vinny, what it means is, in fact, that power would then be in the hands of the states. What the conservatives like to say is that the abortion is not mentioned or covered by the Constitution. So there shouldn't be a federal protection for it, and the states then would be allowed to do their own thing. And it could mean that women would have to go back to state hopping to find a place to get a safe abortion.
So the original Roe v. Wade was 7-2 was the vote, right? Mm-hmm. Back in 73. So Amy Coney Barrett comes onto the court. Again, she can't do it alone. There's got to be 4 others that would agree with her.
Yeah.
So do you think the justices ever talk about this off the record?
You know, I think they do. I think it's all part of the kinship and the gymnastics of coming to these decisions. I think they discuss it amongst themselves a lot. And I think they're in constant conflict with each other with their different ideals. These are extremely bright people, and they're all coming to the table with different ideas and different life experiences. And that's what the Supreme Court is all about. So, yes, I think they're sitting there and they're discussing this. And I think clearly in the camp for conservatives, we have Gorsuch. We certainly have Alito, we have Thomas, we have Kavanaugh, and on occasion Roberts. I cannot see Roberts now writing a dissent with 3 liberals in a case where the 5 others are going in one direction. So you clearly have 6 conservatives who might be going in that direction.
All right, Michael Ayala, appreciate it. Thank you so much. You're welcome.